A very good afternoon, all of you. We have now panel discussion on challenges and trends in CRIP, along with the legal aspects. As the coordinator of the session, I have the privilege to introduce and welcome the extraordinary faculties whose presence here today enriches our gathering. Each of them has made their contribution to their respective field and their achievements are highly inspiring. I welcome Madam Swarupama Chaturvedi, Nirav Pujara sir and Satish Kumar Gupta sir. Please come on the dais, sir. Our first faculty, Madam Swarupama Chaturvedi, is an advocate on record in the Supreme Court of India who is gold medalist in her LLM. She has over 23 years of experience in legal profession, comprising teaching for 6 years in National Law School of India University as full-time faculty, and she is also visiting faculty in 3 foreign universities. In addition to teaching experience, she has over 17 years of standing at bar, representing various clients as well as representing IBBI before Honorable Supreme Court, High Court and tribunals. Her recent role as Additional Advocate General for the state of Madhya Pradesh before the Honorable Supreme Court of India showcases her extraordinary commitment to the legal profession. Notably, she has represented the Election Commission of India and State of Uttar Pradesh as standing counsel before the Honorable Supreme Court. I request CAIP Sunit Shah to felicitate ma'am. We have our second faculty, Sri Nirav Pujara sir. He is Chartered Accountant and a member of ICAI. He is also Insolvency Professional registered with IBBI. Sir has over 19 years of experience delivering business consulting, restructuring services and operational turnaround advisory services. His professional journey has taken him across border, including a significant stint with Deloitte UK member firm for 2 years. His core industry focus areas are financial services, real estate, steel and cement sector, where he has deep experience in handling matters in both operational turnaround, risk management and corporate finance restructuring matters. Apart from this, Sir has worked in oil and gas, EPC and manufacturing sectors. He has also involved in a voluntary liquidation process and resolving cases in line with RBI circular for resolution of stressed assets. I request Sir to felicitate Nirav Pujara sir. We have our third faculty. We are honored to have Mr. Satish Kumar Gupta with us. His academic background includes an MBA in Business Management from XLRI, Jamshedpur, and a degree in Mechanical Engineer from Delhi College of Engineering. Sir has over 25 years of professional experience in stressed assets resolution, cash flow monitoring, and credit risk management. He has acted as a resolution professional for SR Steel India Limited, the largest and complex account under IBC. His outstanding achievement as he is awarded for the first time in India prestigious Turnaround Management Association 2020 Mega Company Turnaround Award for his role in resolving SR Steel India Limited as insolvency professional, which reflects his remarkable contribution to the field. I request Sunit Shah sir to facilitate the sir. This session is moderated by CAIP Sunit Shah. Sir is Chartered Accountant and member of ICAI since 2002. He is the founder partner of Skies and Company Chartered Accountant and in active practice for more than 18 years. His core area of practice is insolvency and bankruptcy, company audits, bank audits, forensics, valuation, project funding, and financial and tax advisory. He is qualified insolvency professional certified by IBBI, forensic auditor by ICAI, DISA qualified, independent directors, and is also qualified social auditor by Institute of Social Auditors of India. He is currently pursuing the PhD in Insolvency and Bankruptcy. He has been acting as the member of Managing Committee of Ahmedabad branch of WIRC of ICAI and Director in Board of Faculties in Nirma University. Since inception of Insolvency and Bankruptcy Code 2016, he has been acting as an interim resolution professional as well as liquidator in various companies admitted in various sectors, has successfully handled 15 plus matters involving total debt size of more than 10,000 crores. He is also speaker on subject of IBC at various forums. It is my privilege to felicitate him.
Good afternoon, everybody. I am quite conscious to the fact that pre-lunch session is definitely not the one which should be not having any option of giving you benefit of bonus timing. So unfortunately, instead of bonus timing, I'm already in shortage. So now, while we deal with the law, which is all about time, value, and money, I'm already starting very late, and I will try that I should still be able to honor the timeline. So the session is very interesting one, the challenges which is we are going to deal with. But let me share like what very generous introduction was given. But when it comes to IBC, I stand at a different side where you all are standing. So I have been representing IBPI, and I was privileged to representing their very first litigation itself. So my role as counsel of regulator has a different experience than what you would be experiencing with IBC. So I was suggested by Sunit that I should share my experiences as well. But considering the time, I would not share much experience, and perhaps I will leave on him to ask whatever he would like to ask, and then we can proceed. But if the question doesn't fall in the way I want, then definitely I'll take some time towards end, and I would share what I want to share. Thank you so much.
Yes, sir. So we'll start directly with the panel discussion, right, as we are some short of time. Yeah, ma'am. So first question for you. Can you broadly talk about the legal issues in IBC framework that are yet to be settled, like the MLA versus IBC, ranking of security interest post relinquishment? So more of if you go on to the general part, it's about the question will be specific to the PMLA part. Can you just
I think it would be good to, it will be like taking forward the last session itself. So there was discussion about PMLA versus IBC. I still see that there is nothing like PMLA versus IBC, and it's always there are two different statutes which exist in two different worlds. So while the issue is still being settled, and it will be settled, where it overlaps, so there is overlapping for sure, and that's where we think that there is a conflict. So not every overlapping is conflict. It's my personal view, and since I'm asked to give my view until Supreme Court come up with the judgment, I'm free to give my academic view. So I don't see any conflict in between both, although there is overlapping. Now, where is the overlapping? You all are experienced more than I would be explaining. The asset, which is the key when RP performs his job to maximize the value, and where the conflict comes and overlapping happens. PMLA is basically creates an offense where it's not only offender which is getting punished for the offense, the amount, the proceed which is realized, and the money wherever it is used, that money trade, everywhere the money is considered as the bad money. So bad money, if there is an asset in your resolution which is a bad money for ED would like to consider for attachment being their own money, because it is money coming from the bad amount which is offense. Proceed of end of the day, even if ED attaches, end of the day, the offense, punishment, everything will be followed by the offender. But then the asset, if it is a company, if it is attached, it's going to work somewhere. So I'm quite hopeful the day law will be settled, there would be definitely no conflict, because whatever asset you have, when your mandate is about maximizing the asset, if there is an asset which is proceed of bad money, you can ignore that. Of course, it would be very unpopular view when I say that, because then your haircut, etc. will increase. And there can be a company which would have maximum, where there is bad money. But this aspect, that where that amount is a bad, proceed of bad money, and where it is, we need to do, as RP is supposed to do its duty as per regulation, until there is a judgment passed that this money is proceed of bad money and it is gone in ED. Everything is for you to maximize. So there is overlap for sure, where law is yet to be settled, but there is no conflict as such, because both operates into the both.
May I
Yes.
to
Yes, please.
Regarding this PMLA attachment, recently, just 15 days back only, there is a judgment by Gujarat High Court. So the issue was essentially wherein the asset sold by the liquidator of ABG Shipyard, that is the sales certificate, done to a party. So that particular asset was attached by PMLA, and the sale could not be completed as the part payment was paid. So thereafter attachment came, and that attachment was also confirmed. So that was challenged by the buyer, and recently Gujarat High Court has ruled that PMLA statute is prior to IBC, and secondly they have also cited 30A, where the past misdeeds of the promoters and all that they should not get. So they have ruled in favor of the buyer that no attachment can be carried recently. So I think that's what you have said that so that has already been getting reflected. Yes.
It is getting harmonized slowly by all high courts,
Right.
and even Supreme Court is considering.
Right.
So I think somebody referred that the mandate
Yes.
is coming in next month. So
Correct.
soon it will be. There has to be harmonization, and there will be. I'm quite hopeful about that.
Yes, sir. So specifically, if we talk about this PML, if we discuss section 238 of IBC, so straight away section 238 of IBC, it says like it overrides each and every law of this country. So whether this attachment will not be overruled by 238 simply, or we just have to wait for the judicial pronouncement that will be coming up.
So here, I think the answer would be what I wanted to answer to talk towards end. I think I need to explain that at this stage itself to understand. Law making process. One is law made in the parliament, which is enactment A or enactment B, and there is provision in some of the laws that it overrides. Another is getting the same law interpreted by the court, because legislation cannot foresee each and every situation which is before the legislator at that time. And I think IBC is the great example of that. The moment IBC came into scene, the real estate JP issue, so many sectors came up with new challenges which I think IBC has not foreseen. So when the law came, it says yes, it overrides, because we should not lose sight of the fact it was amending 13, 14 more acts to harmonize everything. And when we say that a law is coming which is dealing with a subject area which was earlier being dealt in so many laws, and there was no umbrella, and now it is coming. So this is a kind of standard provision which is absolutely fine, and if literally interpreted, yes, it overrides everything. But then when judiciary, the second way when law gets made, but we don't call it law making, it is interpretation of law. There are various principles under which judiciary operates. When they define the meaning of each and every word which we read, a non-legal professional may understand the same differently, a legal professional would understand differently. Only difference would be the principle of statutory interpretation. So one is literal interpretation, yes, it overrides everything. Two, there is another principle of harmonious interpretations. And principles of harmonious interpretation further operates within many laws and maxims, rules and maxims, which says no provision of any law should be left abundant until unless there is a conflict. Now, why I say there is no conflict? Because while it says that there is objective of IBC is different, objective of PMLA is different. End of the day, both have to work together. What PMLA does, it tries to clean up the mess which has been happening in the industry due to malpractices. If you look at, if somebody analyzes the data of companies coming into insolvency, most of the companies, I'm not talking about small companies but big companies, most of the companies are there because of corporate siphoning and many such things which are the offense. So once PMLA effectively executed, these problems are going to be reduced at certain stages, and I think IBC is going to help in execution of PMLA in certain ways, and PMLA is going to help IBC in certain ways. So both are correct things. One, what High Court has said, that yes, that law was earlier, it was for a different purpose. I'm sure when we read the judgment, the objective of both acts would have been definitely discussed in the judgment. So when there are two different objectives and then there is no conflict, court every time, especially with IBC, we can see every judgment has a personal application. Looking at the category of creditors, debtors, if we see that waterfall, the way it gets decided, most of them, like farmers example somebody did. So judiciary is conscious with which class they are dealing and who is going to be affected or benefited. So now in PMLA and IBC, if both together harmoniously gets interpreted, then this law dominates everything, but that law comes to tackle a certain type of offense. Here it is to maximize the value, but it doesn't say, when it says it has privacy, that criminal law will not override. I don't remember the section number, but where even moratorium related provisions are being made that every civil proceeding would be stayed, it doesn't say criminal proceedings would be stayed. So court is conscious to the fact that whereas it gives primacy on all civil laws, criminal laws takes its own course. So in that way, I'm expecting the interpretation might finally comes from the Supreme Court, because those are two different laws altogether. So it's not conflict, it is not conflicting judgment.
Yeah, so maybe I'll also just start. In my experience, the PMLA issue in IBC, CIRP, it is something which, after 32A is a fairly settled law, wherein with the moratorium existing, even if there is a enforcement agency coming, you are able to impress upon. And if there is some, at times, many times, district court, high court order can come through. But obviously, if you go through the process, you will ultimately see IBC is able to ultimately sustain and reside over a PMLA. But the challenge which comes is, many times the holding company is in CIRP, and what we have seen is that assets can be created in SPVs below the holding company. Now the holding company as assets is basically the SPVs, which are having, it can be having other assets, for example, real estate or anything else. And if there are PMLA or enforcement agencies acting at these subsidiary levels, then at this stage at least you don't have the benefit of protection at the one level down. So there, even if the holding company is in CIRP, you will still have issues in getting a resolution plan or convincing investors that how are you going to manage the enforcement agencies or PMLA at one level down. So this is one area where that becomes a challenge for a successful resolution.
Alright, so we wait for the Supreme Court judgment to have
Yes.
some better clarity. That is what
Yes.
we can do as of now. Nirav sir, you are more on to the resolution part. So you handle the resolution of several good companies, including Reliance Capital, probably, if I am aware as of now. So sir, can you just elaborate on the cement, the infrastructure, the real estate and the construction part? So I'll merge those two question. So, considering your experiences in fundraising as well, what typically is the mindset of RMI structuring acquisition of a corporate data? So, how you pitch in the buyers, the potential buyers, like the resolution applicant? The company is already running into the CIMP. Maybe the specific sector, that may be cement, steel, capital, infrastructure, any space. So how you pitching to the customers or the resolution applicant to bring that big amount, big chunk of money to this, to acquire this company? So what are the marketing strategies that we can have?
Yeah. So I'll come to that question, but maybe before that, in the earlier session, there was a reference of RP being an all-rounder, and also something what you were saying that RP obviously has a difficult job and has to manage multiple areas. So many times this is being quoted that RP needs to be an all-rounder. So I have different views, and for this I will use a reference of mythology. So we know in Ramayana and Ram Bhagwan is Maryada Purushottam, while Ram Bhagwan is God himself, but many times he needed help. He never used to go himself. He had many of his supporters, allies. He needed Lord Hanuman, he needed Angad, Sugriv with his army. Only then he was able to overcome and achieve what he had to achieve. And as compared to Lord Sri Krishna. Now Lord Sri Krishna in Mahabharata is pure all-rounder. He is a very good son, he is a good cow, all of that. And he can do miracles. Lord Sri Krishna does not need any help. He is one man army. So putting things in context of CIRP and RP, I feel the RP is Maryada Purushottam. And the Maryada is IBBI guidelines is the RP has to follow. So RP is not capable of doing miracles, but RP has to follow the process in a very dutiful manner, without any deviation. Now, what is the ultimate goal and objective of the RP? That is a successful resolution. Now, for a successful resolution, what is that key success factor? That is value maximization. So this is the only objective which the RP should have in mind. Knowing what is required for a successful resolution, and for achieving that, what are the other challenges which will be coming in the way of value maximization. So whatever the RP will be doing is only to achieve the end goal. Now for value maximization, the starting point being itself that the company is in a code-driven process that too instituted by the financial creditors. Whenever the financial creditors or lenders are taking charge, that means the equity value has gone zero. Right? And no matter what, it is going to be traditionally, not only in India, world over, globally, this is the whole concept. Lenders taking charge, equity value zero, that means it is distress. Now, no matter what valuations we can do, the buyers who will be coming and seeing this will be seeing from a distress perspective and will want that deep discount. And now, obviously, with IBC has had a fantastic run over the last 6-7 years with various nuances and amendments, also clearing the law. Now we have some investors who purely look at distress deals. So the starting position itself for the RP is, against the odds from a value maximization perspective. Now, knowing, depending on what the asset is and what condition the asset is, it can be further difficult. And that ultimately is the major area which the RP has to focus on as and when the asset is taken charge of. Now, whether, depending on the industry sector, whether it is steel, cement, or whether it is a real estate project or a FS sector, the nuances will be very different in terms of what type of challenges one will face. Mainly first from a value protection perspective, and then second is what all can be done from a value maximization perspective. So if I can maybe, I'll quote two examples of a cement sector case which I had handled, and both very different situations. One was a cement asset which we took over, which was in running before the CIRP admission. Only, I think, before 3-4 months back, only the unit had shut down before the CIRP admission. The reason was because all the vendors, transporters, etc. had gone on strike because of non-payment, etc. So the company was not able to manage buying material on credit. So for manufacturing, obviously cement, steel, I'm sure everyone is very experienced here. Working capital is a big issue. And after default, bank lines get freezed, there is no additional working capital. And the minute there is news of the company going into IBC, and this one I'm quoting one of the very initial cases, Benani Cement, which was in 2017. And those were early days of IBC. And obviously the knowledge of IBC also, which it exists now, that time was very limited. And we are talking about a cement plant in part of Rajasthan, away from city, etc., where you have transporters who are required to move material, you have coal suppliers, you have labor staff itself. When the news of company getting into IBC was announced, it was the rumor, or basically the talk out there was ये company का दिवाला हो गया है, तो पहले जाके पैसा है. So people used to come in hordes every day, and we had to deal with that. The point being here was, but again, the fact that the asset condition was good because it was in running till a long time, and it was only 3 months before the shutdown. Now, having said that, all the ecosystem was with the company, that is the employees, the contract labor, etc. Everyone was still continuing. And you know that if you continue with all the costs, that means you are continuing with all the overheads. And in fact, the CIRP cost clarification, I think, came in only subsequently once we started that case. But either ways, even at that time, one of the basic things which was done and which now is a necessity with the CIRP cost clarification, that what are the costs which you are running during CIRP and whether you are able to recover it or not. So if for a cement unit which is shut, if I am running with all the costs associated, my monthly loss or the annual loss itself will be so huge. So there what we did was, we basically did an assessment in terms of what is the requirement for restarting the unit. And one of the major factors, because as I said, the asset condition was good. What was required was mainly working capital and convincing some of the suppliers that, you know, we can repay the money in a periodic way. That is the news. So we were able to successfully convince, in fact, also raise interim finance and restart the operations. And in fact, we turned the unit into positive EBITDA over a period of 6 months as well. And that was a major factor for the recovery which we had on that particular unit, was because the unit started operations and recorded positive EBITDA. As against the scenario, if the unit had remained shut, then not only the losses would have mounted, which would have eaten up into the financial creditors or the operational creditors payout, because CIRP costs would take priority, but even the investors would not value the business the same way as they would a running business with positive EBITDA, which we could showcase. So this is one example of that. And the second example, maybe a very contrasting case I will give, which again I concluded recently, was Andhra Cements. There the unit has been shut since nearly 3 years or more before the CIRP commencement. So there obviously the asset condition was very different as compared to what we experienced earlier. Again, similar situation, all employees, etc. were continuing. And here obviously in India at times, many times the company is not able to pay money. Promoters, given the long association, do not necessarily lay off people, and many times employees continue as well. So we had a lot of people continuing. When we started the unit, we did the assessment. Again, one important aspect was how to manage the CIRP cost, because the unit was not running. So there, you know, obviously we had to identify what is that critical manpower required for safeguarding of the unit. Now you are a sales team which is continuing without even cement being manufactured. What is the sales team going to sell? So these are the type of assessment which had to be done to also rationalize the CIRP cost, so that at least if you are not able to restart, it's important to preserve the value and not have it further degraded. And similarly, I mean, while this is example of cement, from an FS perspective or real estate, there are different challenges which would have to be kept in mind from a value maximization perspective. Conscious of time, so I'll pause here. Else, I can share with you.
Thank you, sir. Satish, sir, so probably the best case you have handled is about the SR Steel. So we can't let you go without knowing the beautiful or the hard experience that you would have had during the SR Steel CIP process. And it was probably one of the largest of the 12 IBC cases that have been done in India. So if you can just share some bitter or some beautiful experiences that would have happened during the CIP process.
First of all, thanks to Ahmedabad branch of WIRC for giving this opportunity. So I have a small presentation. It will take 5-7 minutes since you are. Will that be fine?
So, as you are aware that, in the initial stages, everybody was apprehensive, how such a large companies would be run, whether it will be possible for the RP or COC to manage the operation. And if you are not able to run or manage, then, the entire IBC process will come to a naught and it will be treated as a failure. And that was the point which was being made by the promoters also before the courts, that, no, you can't take out the promoters and run the company as a going concern. So even before this case was referred to IBC, so there was already a lot of litigations had been initiated by the promoters, that why make a reference to the IBC while the restructuring is going on, and they contended that its operations are very complex, spread all over India, involving large number of stakeholders, and highlighted potential risks to its operations and value under the hands of IRP, which will also adversely affect the interests of the company. So they made out this point, and any failure subsequently would have really impaired the ability of the IBC also to take. So it was a testing time for the IBC and IRP as well as COC, because it was the creditor in control model. Now, so when we are talking of the creditor in control, as you may be aware that earlier banks had never taken the possession of any operating unit because there were associated liability. So they had never taken, and they were also not aware, how the operations will be run, how it will be managed, how COC will be. So we had the litigations ongoing by the promoters. So it was known that promoters are going to litigate during the process. So it was well known. So from the very beginning, documentation was done in a very thorough manner. So what is important I would like to highlight, and for your understanding, is the two SR Steel judgments, and there are two round of litigation which had went up to the Supreme Court, and which had set up the various precedent on the interpretation on the issues which were raised. So I will talk about these two litigations in short. And everybody should read, these two Supreme Court orders. plus Innoventive, Swiss Ribbon. I think these are remarkable orders, and which you should not only refer, but you should read from first page to the last page to understand how the law is evolved. Now, in this case, as the promoters were highly litigant, so their company, even before the plan could be considered by the COC, okay, they had gone to the court, NCLT, that they would be considered ineligible and their plan would be rejected. So, and NCLT in its own wisdom, they state that okay, COC can carry out the process of, but they will not take any decision on the approval of the resolution plan. So you can very well understand, it almost the process gets stayed, and then subsequently Supreme Court held that no resolution applicant has got the vested right till the time plan is considered by the COC. So that was a very, very important Supreme Court judgment, which is not so much talked about, because this really helped the resolution applicant not starting any frivolous litigation till the plan is considered by the COC. So in this round one was essentially about the ineligibility of the resolution applicant. So that is essentially on the section 29A, and this essentially covered the interpretation of the section 29A, and I think it was it was very, very widely interpreted, and after that I don't think it required further interpretation, except for in the Appu case, Appu Hotels case, Supreme Court order recently in May 23. And and Supreme Court, first time they had to contend the factors of the control, that whether positive control or negative control. And the SEBI and other institutions had introduced the concept of the control from 1995 onward, but there was no judgment by Supreme Court on the issue of the control. So the first time Supreme Court had to discuss the issue of the positive or negative control, and in this case they decided that it will be the positive control which will matter. And thereafter, this definition has been used by SEBI, CCI, for various their various other considerations. Round two was essentially on the distribution. Okay, the plan was approved, and distribution to OCs and FCs. So we have talked. Everybody knows that. What kind of distribution is currently made, but what we went through and what was the NCLAT order which was challenged, and finally that was reversed by Supreme Court. So in NCLAT they had decided that all financial creditors form one class. Okay, there cannot be any distinction between secured or unsecured financial creditor, so they will be treated equally. Secondly, operational creditor will also be paid the same amount. Okay, so everybody is equal, financial creditor, operational creditor. So there was no distinction, and there was no extinguishment of claims, and even the disputed claims. Okay, disputed claims of 14,000 crores were admitted by NCLAT, and they were also being paid the same amount. Okay, so imagine what the secured, I will say the major financial creditor, they were getting earlier 100% of the principal, their percentage, everybody was getting now 60%. That is the one class only, and 60%. So obviously, that is what we had to go through. That was the NCLAT order, and that is what was challenged by the banks, and finally, it was ruled that it will be the COC commercial wisdom which will decide the distribution, now whether to secured or unsecured. So that is what has been very, very important. Now from the how important it has been, I will say that total recovery in the process was around 50,000 crores. Okay. So which amounts to today also, if we take it, around 20% of the total recovery under IBC. So I will just leave it at that. But I can, if you permit me, I will just cover the various challenges which are being faced. So what as IP, I know the legal. These has been discussed also. But the various challenges which are being faced by RPs are increasing compliance with the reduced fees over a period of time. That the compliances, whether it is a corporate debtor compliance, GST, or any tax compliances, okay, or IBBI or IPA compliances. Now, these are all increasing over a period of time, and the remuneration is going down. So it is very important for IPs, to use the existing infrastructure or the resources of the CD as much as possible. Same way, cash flow and liquidity constraint. Most of the cases which are coming, they have the liquidity problems, and which impact the in addressing compliances as well as resolution of them. Evolution of IPEs is another area, that is the corporatization of IP functions. Widening role of COC's commercial wisdom. So mostly we see that COC is role has increased to all the now it encompasses all area now, because they have to approve all CIRP costs. And recently there was a disciplinary action that against one RP, that he has not taken approval of one particular CIRP cost. So that means if you have to file any avoidance transaction or appointment of legal, so you require COC's approval for each and every cost to be incurred. So that is something which is means that the IP will not have any power of its own to keep the going concern or incur expenses as well. There are overreach of various investigative agencies. We have seen ED, CBI, and PMLA. There is an overreach, and generally what happens that promoter, they say now RP is there, please follow up with the RP, and so there is a lot of huge work which goes on. And avoidance transaction is another area. If it is relating to any of the COC member and it is not to the liking of the COC member, obviously, then it creates issues. Okay. So I will leave it that with the time.
Thank you, sir, for elaborating in detail about your experiences in SRST. But it's not just a small matter. I think so it will take much more time to deliberate on this particular case that you have done.
I've highlighted a small portion of that, so that we talk about these cases or refer, but how it has evolved, because it is not the Supreme Court, it has gone through NCLT, and then Supreme Court. So there is a process, and one has to see, how as I said, NCLT had a completely different view of how the distribution should be done, and then finally Supreme Court decided, and then then as well.
What is the total time period that it took to complete this process? Just number of days or months, if you can let everyone know.
Right. So we could so if we exclude the time period of litigation, so it is 180 days. But if we take the time period as such, it will be 2 years or 4 months. And you have to see that the matter went to Supreme Court twice.
Still it's much more effective. 2 years, 4 months.
Right.
It's much smaller a time, I guess.
Yeah, correct.
There is no such
Considering
big
that
idea, yes.
matter had to go to Supreme Court twice. But one good thing was that when this matter was taken up, whether NCLT, NCLAT, or even Supreme Court, the entire board was discharged, and only this matter was taken up, and they used to have day-to-day hearing mostly. So that, I think the system also recognized the importance of this particular case.
Sumit, if I may add, I must say that SRP is a legendary case in IBC. And as IPs, we are obviously enjoying the fruits of the judgment which we got from Supreme Court in terms of, even the 29A, the role of RP, what needs to be done, the class of creditor treatment, and so on and so forth. So, in fact, on behalf of IPs, I thank and congratulate you on this.
We have such judgment to quote everywhere.
Thanks a lot. See, I just wanted to again show one slide on RP's role, and in our judgment it has been very, very clearly enumerated what is the role of RP. So I was very clear that RP is an independent person. His role is not adversary. Whether it is a promoter, generally COC or even the banks, and they will be adversarial to the promoter. But you cannot be, as RP, I cannot be prejudiced to any promoter unless I find that they have done something wrong. Okay, like when the promoters come or the director come to COC meeting, banks treat them very badly. Okay, but there is no reason why RP should be treating them badly or talking. So that is one thing. Other thing is that independent means I'm not taking any commercial decision relating to the resolution plan. I was under a lot of pressure by the COC that distribution, because that time it was not decided by the courts that it is the COC who has to decide the distribution. There were interstate creditor issues that who will decide the distribution. Okay, COC. Part of the COC earlier wanted me to decide the distribution, then one creditor opposed. Then when it was not suitable to him, then he again said no, then RP should only do. But I said, no, RP is an independent. Because this is a power, you cannot have certain powers which can be abused also, and a lot of allegations can come on the RP also on giving this kind of deciding on such kind of issue. Same way, the disputed claims. There was no precedent how to essentially verify or admit the disputed claims. So I got different legal opinions or legal views from the very big firms, experts. It's like, no, you have to make the best estimate, take opinion from the experts or senior cons. Then I said, who will decide the matter which is pending in High Court, Supreme Court, even some matters were pending in Supreme Court. That will mean adjudication. So that is how you have put the notional value at 1 rupee, and that is what was upheld by. And that made the life very, very simpler. That matter which is under dispute has need not be decided by RP or giving an estimated value to that. So a lot of litigations, I think RPs were saved on that part.
One specific question, two questions I have. Whether can you broadly talk about the legal issues in IBC framework that are yet to be settled? I think so that my second question will also be included in the same. That can any person from suspended, so this is a section specific question for all of you, whether if you can, ma'am, if you can say about suspended board of management to be appointed as a key person of the company after the completion of the implementation process. So 29A, so the word implementation, as we read the plain reading of section 29AJ, reads that any person who shall be promoter or in the management or the control of the corporate data during the implementation process should not be eligible under section 29A. So this question, this provision overhauls everyone rather. Because if we take a practical experience, like a company who was a management of the company, we got the resolution of the company. During that time, the management of the company is not allowed as per section 29A to be into the management or to take over the company. Now the company is into the implementation, but the implementation is being done. So it took around 1.5 years, 2 years to complete. After that, the original promoter, the director of the company, I call him. I say you become the director in this company to manage the affairs of the company, whether that is allowed or not. If you can.
I join you in saying that this question is for all of us, not only panelists. And although it is going outside CRP, but this is definitely a legal question which is staring in front of all of us. And today and tomorrow, someday we are definitely going to face it. So far, this issue is not before any court. But then, yes, this is a valid point. If I'm getting you correctly, that today somebody is not eligible to get something as per law directly. Can that person be indirectly entitled to get? The simple answer we will give immediately no. Now, then I'll join with the second question. Can we bar somebody forever from getting shares from any company? The again question would be I think no. Because when statute has not restricted by any provision that one cannot buy share of any company, then the person who was in key position at the time the company was in default, how can we restrict him or her at that time? So I think this question is staring before us and someday we are going to face it. But with common sense, if I look from IBC perspective, the person who was in key position when company has died in a way. I mean, we do call it revival, but at the same time, we know that at that time the company was dying. Can that person be again trusted enough? So I would definitely say no, it should not be. But then
buying shares is different from
no, so I'm coming to that, why I'm relating that. So now the answer would be that no, that we cannot leave that company, we cannot trust same person again for running the company. Now if I'm making it specific actually, that managing director. So A was managing director when the company X was in default. Now resolution plan has come and company is revived and implementation has happened. After a few months or maybe a few years, A buys shares of that company, maybe good enough or having good relation with the existing management at that time, and existing management say now you are going to be the managing director. In my knowledge so far, there is no law to stop that. But can from IBC, the spirit of IBC, we find it justified? So my answer would be that this is question for all of us. Because why I said the buying share I mentioned, because to become managing director, one has to have some share. So if transfer of share is not restricted, not prohibited, then the person can be offered managing director position also, if we see from the Companies Act perspective. So why I made it question for all of us, because I believe that maybe chartered accountant is more competent to answer this question, and then if actually this situation comes, what would be the answer?
No, I think this is a very interesting question, and Swarupama ma'am has well explained. Legally, I will maybe from an RP perspective, I will say there is two nuances. One is during implementation, and second is post implementation. During implementation, because there's a monitoring committee, part of the resolution plan, the straight answer would be no.
Yes.
But after implementation, as ma'am said, currently there is no law which prevents. In fact, I don't think it even talks about a failed promoter acquiring any shares. So KMP position, obviously it does not, it is not at all prohibited. But having said that, I don't think it is that easy. Because in our experience, even now when we deal with investors, there is one, while there can be talks of, okay, the earlier management, because running a business in India is not easy, right? Even taking over the company is one thing, but running it successfully is another thing, and many times the promoters are very well deeply entrenched with up, and you need their support in some way or the other. But the way currently the IBC code is drafted with the 29A restrictions, and depending on whether that promoter is classified as a willful defaulter or not, in the interest of the management or the new shareholder who has come in, even if he wants to think of putting the earlier shareholder as a KMP position, it won't be viewed well with the external stakeholders, right? Because for any business, you would need access to funding. So it is not just equity which you would need, you will also need credit. And creditors with the IBC and the way the law is drafted are very particular. Not only I am talking about public sector bankers, but even private sector will view this very adversely. If you are seeing an earlier defaulter taking a KMP position. So while the law is not maybe clear, but I think the way the law is drafted, it has enough restrictions. Whoever wants to do it will have to pay a steep price from ease of doing business, I would say, and that is why I don't think this is being seen anywhere till now.
So I will say that 29A is just for the limited purpose of the determining eligibility of the resolution applicant, and not to debar anybody from for the life. Okay, so and that too for that particular company, they can't be resolution applicant. And as regard during the monitoring period, yes, completely no, that the same person cannot be. But however, they are always free to join later on, because finally, there will be new shareholder, new money coming, and if they are willing to ride on the ability of that particular old KMPs also, I mean that is their call. Now because the earlier lenders or the earliest creditors have been settled, so they cannot be really blocked unless mentioned, either they are willful defaulter or some criminal cases for diversion of etc. are going on. It will come in the way also see, because some of the business failures may not be entirely due to the management failure. So the development of entrepreneurship, that exit insolvency also provide the exit, also ability to re-enter the businesses. So even in SR also we see, even though the earlier promoters they got out, but they are free to take up new ventures or that entrepreneurship doesn't have to be really given unless there is something malified which is proven by the court or some actions being taken. Otherwise, I think as such entrepreneurship has to be promoted. So that is
So
a
I
limited
think
point.
what I understood that panel agreed to, I'll just summarize, that legally there is no bar, and then the person can be being an entrepreneur, can be back. Morally, as Mr. Pujara mentioned, that morally it would be seen. In law and morality exist separately. So there is always something which could be moral, but it could be legal. So in that way, we can conclude, answer for your question is that yes, morally it might not look good, but legally it is I need to argue, I would argue it as per going against the spirit of IBC, and I would definitely like to prove that how an entrepreneur can misuse complete IBC and then get the company back after 90% or whatever the haircut. So, I mean, we have a scope to practice even more now and get more interpretations done. IBC is not yet settled and it is still in the process in that way, I would say. I would, should have gone to
Again, we have paucity of time, so one last question, and because I wanted to go on to the rainbow papers, but probably if I go, I think so, we won't be able to have lunch, coffee, anything more. I also acknowledge the presence of RP of rainbow papers here. RD Chaudhary sir, he is here itself. So we could have a certain deliberation from him as well, but not discussing rainbow as of now because Pooja Bedi ma'am, she is also acknowledge the presence ma'am. Welcome. We are taking the rainbow papers during the liquidation in the next session. So one last question. So 5-7 minutes we have. What about the COC, the commercial wisdom of the COC? If you can just deliberate in general, or what are the, as we said, which are yet to be said. So if that can be correlated, the matters which are yet to be settled along with the commercial wisdom of COC.
Yeah, so as we discussed and we see the way it was going, in between I just started the discussion how law is made. One is by parliament and then second by interpretation. So IBC is beautiful example of settling the law by court from NCLT and CLAT and then going to Supreme Court, and of course on many occasions High Court has also played a significant role. So in that way, since everything looks like getting settled until your questions comes which show us that what else we need to think and discuss. I have got to appear in a case which is a very beautiful example of things not settled which we think is actually settled. So I just wanted to share that case, and good that you asked, otherwise that is what I was going to talk in the end. So by now we all believe sitting in this room that wisdom of COC is the paramount and IBC is very much settled on this point. I hope that our belief continues, but it may not continue as well. So there is one case which is before Supreme Court, judgment is reserved, started from NCLT New Delhi, traveled from NCLAT and then till Supreme Court. At the stage when we believe that the law is settled as far as COC wisdom is paramount. Now in that case, when resolution plan was before NCLT for getting it accepted, learned members said, that no, we don't want to accept it because we feel that fair valuation doesn't look like it's fairly valued. Now, there was no violation of any procedure. RP has done fantastic, everything was as per law, but just that bench felt that for ABC's reason, that valuation looks low because haircut was more than 90%. They decided to put that resolution plan on hold. Nobody was objecting, not a single party, because all procedures and it was with all wisdom of COC, which is the law settled by Supreme Court, it was accepted plan. But NCLT decided to put that plan on hold. Then the successful resolution applicant has approached NCLAT. NCLAT, to the biggest surprise, while the precedent follows that Supreme Court says that the COC wisdom has to prevail, NCLAT uphold the judgment of the decision of NCLT and said we can't treat NCLT just as a post office that they are there to sign. If they have some reason to believe, I would just read few lines. The bench was not convinced only on the reason that fair value of the asset was not projected, and then the amount was not justified. So all these reasons which is already discussed earlier when the Supreme Court judgment is passed. Now in this case, when this case was before Supreme Court, that your own judgment is not being followed and NCLT has kept our plan on hold and CLAT is upholding this judgment, Supreme Court has decided to know that can we say that NCLT bench has no power once because the COC wisdom has to prioritize and the plan is approved. So I was having opportunity to assist Solicitor General on this point. Government has taken its view over there. Arguments are concluded, judgment is reserved. But why I said that I just hope that COC wisdom would prevail, because the bench got changed. The bench which issued the notice and the bench which has finally heard, because that judge was retired, honorable judge was retired. Now judgment is reserved. We are yet to see that Supreme Court depart from the earlier view or follows the same. Because the moment they decide at first go that they want to give indulgence, we do have reason to believe that there could be. But since the bench has changed, let us see what comes. So, like that, there are issues which are not yet settled, because questions, issues, challenges faced by you people come as legal substantial question of law which we argue over there. But even issues which are settled sometimes become not settled. So that is useless. I think it is ongoing process and it will go on. Thank you. Yeah. No, COC has approved the plan. NCLT has not approved. COC has approved the plan, and then RP has come up with the plan before NCLT for approval. NCLT decided to keep it on board and not to approve.
I think what is here is it was talked in the earlier panel also, COC code of conduct, or I think that if that is there, it will really help having some codified conduct from the COC members, because one or two cases it should not get really settled at the Supreme Court, and where one particularly COC may not have really acted in consonance with the established processes.
Interestingly, in this case, debtor, creditor, RP, and government all are of the same view. They are supporting the COC wisdom, but court is yet to take forward.
Right. So the court will take obviously that nothing should be arbitrary, or it should not be perceived to be that. So I think that is also because the balancing of the value maximization principle, whether that has been followed by COC, and balancing of all the stakeholders, I think that also duty is also constituted upon COC. Now whether while approving the plan, now these parameters are ticked off or not, I think that is again a question mark, and that is where the code of conduct will essentially facilitate that.
In this case, if any of the party would have taken divergent view, then there must be some suggestion assistance for framing the guideline. But NCLT and ICAI are of the same view, but vote cannot be represented over there. And parties assisting the Supreme Court all were of the same view that COC wisdom should be considered. Now, let's hope if court has internal assistance to frame some guideline, but this was a perfect case where the opportunity is before Supreme Court to give guideline for COC, or some standard rules.
IBBI has issued the discussion paper, and it's a long time back, but for whatever reason it has not been finalized so far. There should be, because I can give various examples where particularly the RP has to essentially they pass a resolution where the RP is supposed to follow, or the direction which will not. So I think that code of conduct is definitely a must. I feel not to really tie up their commercial wisdom or the ability to decide, but I think certain processes and procedures, I think they have to be laid down so that they really act in a manner which is conducive to the IBC process.
No, from an IP perspective, the experience has been COC wisdom is supreme, and at least from an IP running the process, I think it has to be that way, because it is a dangerous zone to be stepping into, which it's better managed by COC. I will maybe give example on this particular case. In fact, I won't share much details, but since the case is already concluded in ICAI for Reliance Capital, so there it was a similar situation of COC president basically giving a view on the challenge mechanism which was run, and ultimately the COC was not happy with the price discovery. They decided to undertake a second challenge mechanism. So it was purely a COC call. Again, so this is the only case where the challenge mechanism was run twice, which was obviously subsequently challenged, but upheld in favor in ICAI as well. So I would say this is a settled law. Coming back to your point, ma'am, I would say this is also a dangerous precedent because this goes back to the same point, because after plan approval from the COC, if there is a question on the fact that the value is not reasonable, because what happens is, there is always a big time lag between the plan approval till the plan implementation.
That's the view government
Now,
is taking.
valuation is always at the ICT commencement date, but at the same time, there can be, based on changes which are happening in the asset, economy, etc., the value at the time of ICT commencement, at the time of implementation can be very different. So, this I would say is a very interesting one.
That's
But
why
from a process perspective, if this gets opened up, then it will really be seen very adversely from investor perspective, because any which ways, there is a view of process being complex, that even after running one round of process, if the price COC does not feel right, they can again run another process. So we always keep getting feedback. Exactly. Finality is the word which we keep hearing. Where is the end game? What is the finality? So this is, I would say,
So that
a
is
double-edged
why
sword.
government has taken the view, government has also taken the view that COC final decision should be considered final. Now let's see what because no party has have divergent view. Creditor, debtor, RP and the government, all four has stood with the same opinion. There was no.
And in Maharashtra seamless, Supreme Court has already decided that liquidation value or valuation, it has no relevance, while COC is deciding on the plan. So I think that this.
And in many cases, the plan is approved below liquidation value, following that Maharashtra simplex. Second thing, not only this case, even in earlier case of Videocon, that group insolvency, the NCLAT has reversed the judgment with the NCLT has come. It is on the different ground, but then again the matter is being lingering for almost 2 years.
So this is where this was a kind of interesting, because Supreme Court itself has says in so many judgments that COC's decision is final, and still one of them has decided to issue notice, and that's where I said it's interesting.
And what you said is also equally true. No, you can't just treat the NCLT as a rubber stamp.
So
That is also equally important.
That's what the question was framed by Supreme Court. But yeah, government has to take the same view then, because considering that there would be no finality and everything will get disturbed. So it was a very interesting question framed by the court, but then, nobody has gone to other side of the view, which would have assisted Honorable Court to maybe frame some guideline, because of only fear that if we enter into this zone, it is a dangerous area, that commercial decision taken by COC, if it is getting upset at any stage, if we leave that option open, then maybe it will ongoing process, and the complete objective of IBC to finish something, conclude something within timeline may get disturbed. So that was the reason why government has also, I was assisting solicitor, so I know the government's reason of not supporting the tribunal decision and rather going with the parties.
Yeah, one last question and then we conclude it.
Which jurisdiction provides arbitration or IBC, especially when it comes to the admission for CARP? Which jurisdiction provides the IBC or the arbitration when it comes to the admission? I'm getting the pre-CARP process. Like there are certain cases which says that IBC prevails, but there are some cases which say that arbitration also needs to be taken into consideration. Like in a few cases, like where the option data or the financial data has invoked arbitration, and after that the IBC application has been filed, which will prevail.
So I'll just require 2 minutes to explain this. IBC starts with the pillars from the fact that there is debt and there is default. It's very like equivalence square kind of situation. So when there is arbitration option in an agreement, it is of course the pre-stage. Pre-stage, when the default is not yet declared, there are some problem. Even if it is default, is not default in terms of IBC, there is problem. Both have decided to go into arbitration and they got settled on Sakhe. Now there is a judgment which has come into not in arbitration but about debt certificate. There is Supreme Court judgment, recent judgment. I would share name with Sunil, where it says if you have a debt certificate by DRT, that would be considered as claim for the IBC purpose. So I would say, in my personal view, that even in arbitration cases, it is so far getting decided on fact-to-fact basis. But if there is something settled in arbitration and that amount is there, it should be treated as part as it is decided by Supreme Court as the debt certificate. I think you meant about realization of that amount.
Decision is not happening.
No, no.
It is only that invocation of arbitration has been started and then he immediately went into IBC application.
So invocation of arbitration is pre-IBC stage. If the agreement permits that, so for admitting IBC, the thing is there has to be default and admitted default. If arbitration is already in the process as per agreement, I would say it's not yet default. Because then until that is decided and that was part of the agreement, how can I invoke even a statutory notice that you have defaulted? Means it is, I am not following the clause which is having the alternate dispute resolution mechanism before exercising my option of alternate dispute resolution. I can't say that you have defaulted.
Arbitration clause will be there in almost all the agreements that we make.
Yes.
Which means that if we have to go through the arbitration and then go to IBC, then there will be a lot of time wasted.
Yeah, that's it. So both options are available. One has to choose.
Different objectives.
Both options are available. One has to choose. But for NCLT, for AA to decide the default, I would say if there is an arbitration option, that should have been ADR should be given priority. But then there are judgments.
Arbitration will create a lot of value loss in that.
And the value loss.
Suppose
There
1
is
year
much
goes
time
in
wasted.
arbitration, then the value which is there or unit is closed down. Like he was referring to the cement unit. So if it is closed down, then it will have a half of the value.
So that's why it is getting decided on fact-to-fact basis. But the option is with the creditor. What you want to trigger. If you want to take your money and you think IBC is the better option, both options are there.
Maybe, but then whether the court will allow the creditor or whether the court will go along with that option of arbitration.
I would say IBC says it dominate other laws, but it doesn't bypass jurisdiction of any other law. So I would say the arbitration option should be exercised, and then one should say that there is default.
If I can add, so the arbitration is ultimately with the consensus of both the parties. Now, if they are pursuing that,
The corporate debt debtor did not come back with the arbitration notice was sent. It was invoked. So then immediately IBC has been applied.
this is we are seeing in multiple cases. Nowadays, financial creditors, many banks are using this obviously as a pressure tactic on the corporate debtor by initiating IBC process in NCLT. Parallelly, there can be talks of settlement also which are on. Many times we are seeing if that is happening, they see there is progress, they accordingly implement NCLT. So it is basically in terms of what the applicant, how they are seeing and what is the best strategy as per them for resolving or recovering the asset. Accordingly, they represent to the court in my experience.
Thank you.
All right. Thank you, the entire panelists, Satish, Sir, Nirav, Swarupama. Thank you for excellent deliberation and answering the questions. Still, I have lots of questions, but they will keep on going. I request all to join for the lunch, quick lunch rather, because we are already running late, and then we join again for the next session. Thank you.